of more than 8 years in handling cases like partition of property, will making, money recovery suits, etc. Welcome, Kenny, to Together Investing Club. You can take over.
Firstly, thank you very much, Isha, for inviting me on this wonderful platform. And good afternoon to everyone who is present with us. Um, can you share the screen, Suraj?
Sure. Can you have permitted screen share? Would you want me to share the presentation?
Yeah. You can you share that?
Sure.
So first thing, before I'll definitely talk about my areas of practice. So basically, I'm a practicing advocate from Bombay. I have been, as Isha introduced, I have been handling cases before various civil matters relating to property or succession planning, or be it any other aspects. I have been dealing all of that. So it's been 10 years that I am in this particular fraternity, but something that I would like to discuss with you all today is about succession planning. So now, can someone ask me can someone tell me what are the things that you plan in your life? For a wedding, what do we normally hire? A wedding planner. For our insurances, we have our insurance agents. For everything that we normally have, the major events of our life are normally having a planner. We do have a planner for it. So can someone tell me, death is a certain event or an uncertain event? Can I see the answers in the chat box? Definitely right, Deepak ji. It's a certain event of life. It is the most certain event of our life. And for this certain event of life, we do not know the timing, but we definitely know when it is gonna come. So we don't definitely know when it is gonna come, but we know it's something that we all will have to go through. Suraj, can you take me to slide number 3, please? Yes. So everything which has evolved has to devolve. That's how the nature goes about. And death is one of the most certain event of life, and hence succession planning. Now, if I ask each one of you, can you all please tell me how many assets do you have? Can you don't tell me, just calculate movable, immovable, I mean, how many assets and what are the list of assets that you know? Can you just tell me one figure? Can you put it up in one figure in your minds? Of course, I know I'm in front of a lot of investors, who are very well versed about their investments, but definitely, can you guys tell me about this part? If I'm sure will not know our investments on tip of our tongue. We'll definitely not know our investments on the tip of our tongue. That is the reason we need someone to, and if we are not clear about where our assets are, how are they, whether they are easy to liquidize or not, how will our legal heirs, that is our next generation or our family members, know about it? Because after all the efforts that we put in is for them. It's for our loved ones and it's for our dear ones, that we put in all these efforts so that they can encash the fruits of our hard work. And if this process is very complex, or if this process is very very difficult, then in that case it's going to be, do you think, are we going to make their life easy or difficult? Easy or difficult? Can I see something in chat box? What do you feel? Difficult. We would like our legal heirs, matlab apne family members, to understand this in a simplest manner, inherit things in our simplest manner. That is what today's session is. I would firstly I would like to clarify, this session is not about encouraging will making. It is definitely not. It is just to create an awareness on understanding why it is important, how to make any kind of succession planning program in your life. Just like have you have your investment schemes, you definitely need you to have a succession planning schemes for yourself. And how, what is the law revolving about around it, and what are the myths relating to it? After that, we'll be open for Q&A. So first thing, for law is about, all I always say is, law is about logic. It's all about logic. So the first very basic thing that we have to understand is that law of our country says that if you want to transfer any property, if its value is more than 100 rupees, any immovable property valuing more than 100 rupees is something that has to be transferred through a registered document. सो बेसिकली कोई भी चीज अगर हम किसी को दे रहे हैं, कोई भी इमूवेबल प्रॉपर्टी, बी इट आवर फैमिली मेंबर्स और बी इट आउटसाइड, वी एग्जीक्यूट अग्रीमेंट एंड एग्रीमेंट हैज टू बी रजिस्टर्ड. वन सिंपल क्लासिक केस इज अबाउट सेल अग्रीमेंट. So that is the law. So anything which is not returned, which is not registered, cannot be transferred. So this is one thing that I wanted to, put forward. So to slide number 5, please. Then I would like to, then in that case, I would like to explain what is law of nomination. Many a times people come to me and say that कि मैंने मेरी सोसाइटी में ना शेयर सर्टिफिकेट्स लिखवा दिए, मैंने शेयर सर्टिफिकेट में मेरे बेटे का नाम, मेरी वाइफ का नाम डाल दिया, मतलब अभी मुझे कुछ हो गया तो वो ऑटोमेटिक चीज उसको हो जाएगी ना, प्रॉपर्टी उसकी हो जाएगी. So to that my answer is no. Nominee is just a caretaker. He is just a trustee of a particular property. He is not the owner of that particular property. So if that would have been a normal practice, so then people would have not executed sale agreement. People would have just transferred and sold their property on the basis of nomination form. So it nomination form entitles a particular person to get their properties transferred, to get the membership of that particular property. It definitely does not allow someone to get the title of that property. Having a title and having a title as a trustee is a very different thing. So one has to add person. If you wish, you can add someone as your nominee so that society has a face or someone to ensure that their dues are not lingering, if a person is no more. But you need to execute a proper document. Now, what are the kinds of document we will see in the next slides? There are two ways, there are two modes of transferring the property. That is during the lifetime and after the lifetime. So basically what I generally tell, that like you have to sit down, you have to chalk down what assets do you have, be it movable, be it immovable, what are the things that you have, and thereafter you can plan your succession planning. So first and foremost thing is to understand whether you want to give things during your lifetime or you want to give it after your lifetime. Supposingly if you wish to give your property or assets during the lifetime, then there are the different modes are you can either gift them, or if it's an ancestral property, then in that case we will have to do a release deed, or we can execute a sale deed. This is the basic method in which we can do. And if it is after lifetime, then it has to be by will and succession law. Succession law comes into the picture only if there is no will. Basically in our country, the law for succession are not codified matlab not a standard law. For every religion there are different law. For Hindus it's Hindu personal law, for Muslims it's Muslim personal laws. There are different laws for different community per se. So if you have not made a will, then the properties will be bequeathed or it will be transferred as per the succession law from the community that you belong from. So, am I clear till here? I you know, is it making giving is it giving clarity about that aspect till now?
Yeah,
Yeah.
yeah.
Okay. So
Yes,
now,
absolutely.
let's understand what is dying intested and what is dying tested. Now, these are very common terminologies. If a person passes away by making a will, he's made a will in the lifetime, in his lifetime or her lifetime, and then if he passes away, then he's called as dying testate. Testate means he has decided कि मेरा क्या प्रॉपर्टी है, कौन कितना लेगा, किसके थ्रू लेगा, who will be the executor of my will, how will the properties be bequeathed, on what terms, on what conditions. That is called a person dying testate. And if the person has not died tested, मतलब will बनाया नहीं है, तो we simply say that he has died intestate. That means he has passed away without making a will. So for example, I'll give you a very simple example. So uh, if he has died intestate, suppose Mr. A dies without making a will, So then in that case, if he is a Hindu, his property will be divided amongst his legal heirs. Now his legal heirs will be his mother, his wife, and his children. So then the property will be all his assets, all his properties will be equally divided between all his legal heirs. Now then to my next slide. So as I said that it is always better to have your internal arrangements. It is always better to have a proper understanding about how you want to, because this is the reason most of the time which creates a rift. This is the reason wherein families come and children come and they fight amongst themselves, because the person who has created these assets has not bequeathed the property with clarity. So one may feel my share is little higher, the other may feel my share is little lower, and this is the reason which creates rift. Sometimes some son, some child, some I have seen some sons, have contributed more for the assets, but when it comes to distribution, because the person has died in tested, the properties are distributed equally, and this creates a kind of confusion. This creates a kind of differences between them. So this is one way out. The other way is there are certain kind of the law, since there should not be any kind of misuse, there are certain ways in which court has decided, the law has decided, that what powers do the court have to give a property to a particular person in a particular way. So you'll have to take, many times you must have heard bank mein FDs hai, and if you want to liquidize those FDs after the person has passed away, the bank asks you to get succession certificate. Basically the idea is to ensure कि यही legal heirs है. There is no strategy amongst the legal heirs कि किसी एक का नाम delete करके बाकी चार ने properties ले ली. So to do all of that, these are the ways for it. Now most important is to understand who are our legal heirs. So if I go by Hindu Succession Act, the legal heirs are mother, married daughter, unmarried daughter, son, whosoever, if mother is alive. The interesting part is father is not the heir, but mother is definitely a heir, because we believe that fathers are independent, mothers are dependent on son. So this is the way we normally transfer our the property. So many a times the rift here arises between married sister and son. So if the son goes and asks the married sister that you give me, you release your share, it creates a rift. It creates a confusion. So these are the points which are to be, considered. So now let's understand the meaning of word will from legal perspective. You know, will in legal words is simplicity intention or wishes. Will is equal to, I normally say, a desire. It just expresses a person's desire, whether he wants to what in what ways he wants to bequeath. Will bana diya, that does not mean कि वो existence में आ गया और वैसे ही वैसे होगा. No, we need to have a certificate probate, so that there is no miscarriage of law, two three people making different wills in their convenience and all of them going for execution. ऐसे नहीं हो सकता. इसके लिए court has said that if you have a will, all the legal heirs have to give consent for it, execute a probate, and then proceed further. So this is one way. So will means it's just an expression of desire. That's it. It is just then. First thing, if I decide today, if I decide that okay, I want to do my succession planning, so first thing I need to what should I do? Let's think about from that. You can, it is not mandatory for you to appoint an advocate and get your will done. You can make it on your own, but it is, I would definitely say that it is important to have a proper legal understanding and advice about how it should be done. So first thing, you need to list down all your assets and liabilities, if any, including your liabilities. List down all your assets, what everything that you can. Decide who will be your beneficiary, for which asset you want to keep whom as your beneficiary. I generally recommend my clients, do not keep multiple beneficiaries. Keep single beneficiaries, so that the process becomes simpler for them and they do not have to go through the complex process. And then choose an executor. In some cases, if the assets are too complex, or if assets are too at too many places, normally people appoint an executor. Executor can be your friend, family, anyone whose responsibility would be to ensure that he executes the will. So you have to choose an executor. Well, appointment of executor is not mandatory, but in some cases where the things are very difficult and you know that there is nobody else who can execute it better, there's nobody who can better understand you, it is important to have an executor. And I would generally prefer that you appoint an executor to a person who is very young, who is comparatively young. An old person is something which will not be recommended from my end. Then let's understand the properties. Slide number 12, Suraj. Now let's understand the what are the properties, what are movables and immovables, what are the things that you can put up in your you know in your will or in your succession planning. So it can be shares, your FDs, your investments, your debentures, your gold, your jewelry, your bank accounts, your cash, your rights or stake in a particular company if you have a partnership firm, or if you are a director in the company, then your rights, your shares, all of them can be considered or can be termed as your movable assets. Those are assets which can be easily moved, easily liquidized, comparatively. So one of them. And what are immovable? Your factory, your land, your offices, your house, all of your flats, all of those things can be immovable. So आपको ये सबको list down करना है. Everything has to be listed down if you are doing your will making process. Then it comes who can make a will. Everyone can make a will, provided the person has to be of sound state of mind. He should be mentally fit, most important, and hence we ask for doctor's certificate for it. Someone who is about 18 years a major, and someone who is making voluntarily will. He's not making, or she's not making will by force or coercion, on gunpoint. No, no, those wills are not considered as valid. And if you ask me what is the ideal age to make a will, I feel if you have good amount of assets and if you are comfortable, you should make it in by your early 40s. And if you have more assets at any point of time, whenever you feel that okay, I have too many assets and that I do not want any kind of confusion, or if you can sense a kind of discomfort amongst your family members, I would generally recommend कि तभी कर लेना चाहिए before that stagnant point keeps enlarging. Then comes, is registration of will compulsory or optional? Well, registration of will is not compulsory, it's completely optional. But as a lawyer, I generally recommend my clients to register the will. A, सबसे पहले, it makes it a very legally strong document. Then it becomes very difficult for anyone to challenge that will, because जब will को execution के लिए जाना होता है, so the scope, the defense for challenging the will, the grounds rather for challenging the will are very limited. And if the will is registered, it is it is way far difficult to challenge such kind of will. Second thing, the stamp duty involved in this particular process is very nominal, because as I said, आप सिर्फ विश लिख रहे हो, आप किसी को दे नहीं रहे हो प्रॉपर्टी. So the stamp duty will not be as per your registration act 30 5%, 2% assets पे कुछ भी नहीं. Your asset का amount may be XYZ anything. The will का जो stamp duty है 1,000 to 2,000 rupees, the minimal one, only that will be your stamp duty. If that makes your document super strong, it enhances the legal sanity of that particular document, then I definitely vouch and I say that it is always good to register a will. Who all do you need? One doctor's fitness certificate and two independent witnesses. That's it. That's all that we need. Those independent witnesses can be your I generally say do not involve your beneficiaries, but it can be any independent two individuals who can be the witness, who will testify that yes, this will was made in front of us and it was made voluntarily. देन कम्स द मोस्ट इम्पोर्टेंट पॉइंट कि मैंने अभी तो विल बना लिया, 2 साल बाद मेरा माइंड चेंज हो गया कि अभी ये नहीं, मुझे ऐसे करना है, या मेरे कुछ एसेट्स जो मैंने विल में डाले थे, आई हैव नाउ लिक्विडाइज देम, आई डू नॉट हैव दोस थिंग्स, आई वांट टू मेक मॉडिफिकेशंस इन दोस विल. कैन आई डू दैट? Yes, you can do that. How many times you can do it? In number of times, infinite times. You can keep changing your will as many times as you wish. You can keep changing it, you can keep amending your wills, you can bring partial modification, you can bring major modification, everything. The will which is last made, the will which is last in date, will be considered as your valid will. And when you every time make an amendment, we call it as codicil. So every codicil clarifies that I am revoking that point and I am making corrections to this effect. You can make partial modification, you can bring the total modification. So making it is always good. You keep making, because you do not know when or how you're going to, how long you're going to leave and what time at what given circumstances. So you keep, there are some clients that we have, they keep modifying their wills as and when the situation changes in their particular, in their life or in their circumstances. Then comes, what if the person has not made a will? What are the kind of certificates that you need require? So basically, we need a letters of administration. Suppose this is an another aspect. So now I am talking about something, the last part of this, that समझो will बना दिया है first ने, तो सारे legal hairs है, they will give consent for it, they will go to the court, probate certificate लेंगे, and then they will go for the execution. Supposingly will नहीं बना है and family is in good terms with each other, all the members, they will appoint one administrator amongst themselves. Okay, this is the person, we have no consent if he administers the property. Administers means uske naam pe sab kuch kiya nahi, but he will act as an executor and he will do the distribution of all our properties. So usko bolte hai administrator. So that for that we take a certificate which is called letters of administration. And if a will has an executor already appointed, then again they have to take that certificate of letters of administration with will. And if there is a will, then it is a probate. And if the properties are only movable, there is no immovable property, then we call it as succession certificate. These are the certificates we require for execution of the will. And to procure such certificates, you normally take 8 to 10 months in Bombay High Court for seeking such kind of certificates, so that you can actually liquidize the assets. I think this was the main brief part that I wanted to throw light on. Suraj, now you can take it forward.
Thank you, Kenny. I guess I'm sorry. I guess that highlights the major aspect of what we wanted, to cover. So, Kenny, we had discussed a couple of questions, and we just wanted to ask those questions as an investor. And like you already suggested, that depending on how complex your asset structure is or how complex your asset portfolio is, the sooner you should start building a will. Or how, and of course in age marks. So if you're beyond 40, you should actually start creating a will. Kenny, a lot of people like me who are in late 20s, and a lot of other investors, a part of our club, who are in early 30s or late 20s, we come across a lot of a lot of a gap in succession planning that happened in future generations. So, how does an investor who in late 20s or in early 30s, who has been through an improper succession planning in the family, can restructure or re-engineer it, or how exactly? What exactly I'm trying to ask is, if an asset is stuck because of improper will creation, how does one go about it?
So first thing is, see, the will which is created improperly, uska rectification is something which is required. So now the person who has made the will is definitely not more, because then only the will has come into the existence. Will comes into life only after the death of the testator. So now in that case, that particular person who is going through this kind of problem has to literally sit and work out on its rectification with his legal hairs. मतलब for example, अगर एक particular flat है और वो एक elder son को चाहिए, and mother and younger son है, and the tested will is silent, or will is not talking about that particular property, so in that case it will fall under succession laws. So then in that case, the mother and the other siblings, whosoever, be it sister or brother, they have to execute a release deed or a gift deed in the name of this particular person, so that he bequeaths it. so that those they are waiving of their share. So basically agar share hai 4 legal hairs hai to 25 25 25, each legal hair will be with 25% share. Now the other three will have to relinquish their 25% and do it. So this, so it has to, Suraj, depend on case to case where they are stuck down, what is the kind of property where they are stuck up, what is the proposition and what is the relationship question with the other legal hairs of that particular person. If the relations are good, if the relations are very cordial, then this can be rectified in a very easy manner, but if it is not, then probably you have to file a suit and seek a declaration or whatever. So that will be depending upon case. So but that particular investor will definitely be conscious that he will not keep any of his properties out of his will or unattended. He will make a detailed compressive will for himself or herself.
Great, thank you. And Kenny, like in your example or in a couple of examples that you've mentioned, we've talked a lot about physical assets like real estate or other assets that can be seen. We also come across a lot of people who do not have a will or who have an inadequate or an improper will, and the problem is of financial assets. For example, stocks, bonds, company papers, and all those other things. So, what is the procedure around that in case a will is not created, or in case the will is not exercised, or there is no proper, legal document around that? So, how does one go ahead and structure that into transition?
So again, in that case, so those are, as I said, it will fall under the purview of succession certificate, because these are not immovable, these are movable assets. And if the person has not made a will, अगर will बनाया है तो कोई problem ही नहीं है, उसमें सब कुछ है. नहीं बनाया है तो all they can get declare themselves as legal hair, heirship certificate है या succession certificate है. They can procure such kind of certificates and proceed further. This is the way out for them. And again, the law for transfer of assets is going to be the same. Be it immovable, the sharing ratio, the ratio in which they will bequeath, all of that is going to be same. So this is the way out.
Great, thank you. And another question that we have had, from young investors or from investors in the same bracket is, how exactly does creating or not creating will affect? Because like we have understood, or like you've also mentioned, even if there is no will, it will still the assets would still form fall under the succession planning or the laws around the succession planning. So does it really matter first? And the second is, if yes, then what exactly to go about?
So see, how do you? It's something. See, it's your hard-earned money. I would say that making a will and not making a will is something which will depend on case to case basis. For everyone, it cannot be A plus B plus C का वो standard formula. I'll give you a very simple example of my own client. I had a client whom I had met 3 or 4 years back. He was in his 70s. Okay, he had two children. Both of them have settled down in US and they are having a green card. They are green card holder there, and he's staying here with his wife. Now the problem here is that मैं will बनाऊं क्या करूं? He had got a lot of immovable assets. Okay, in Mumbai, in Pune, in Lonavala, multiple places. So to him, I said that, are you sure your son is going to come for your funeral also? ये सब liquidize करके इसको assets को वो करना, will it be viable for him? He has not seen India for last 7 years and I don't know when he's going to come. I normally travel every alternate years and stay with him for 3-4 months and come back. So to him, making a will would not be a good advice, for because probate certificate lana karna, his sons are not going to do that. So for him, I had advised him that why don't you make gift deeds? You try to liquidize your assets in next couple of years, you know invested it at multiple places and keep your children as your nominee there and liquidize it. Keep few things or kuch cheeze hai jaise your ancestral house or something which is you want to bequeath it for to them for sure. Execute a gift deed because you know that the fact that they are not going to come but at least unke naam pe hoga to baad mein unko wo sab pura legal compliance or process nahi karna padega. So then that worked for him. But it will not work for everyone. For that, we have to literally understand one's personal background, and then we can give appropriate advice. For example, in one case, I'll tell you again, I'll tell you from live cases that what we see and what we deal with. I had a client who had two sons. The elder son was going to be with the father, the younger son was going to leave, and he was going to stay separately. So the rift was that the younger son was asking for his shares. The father did not have that much liquidized things that he can give things to him immediately. So the elder son said that, okay, I have something from my business, I will give it to on your behalf to the younger brother, so that he can start his life independently, and I will be there. So the father was like, "ठीक है, so then I will make the house in your name." Elder son. So then at the same time, he was worried that what if something goes wrong to me? What about my wife? The first concern that every individual faces is to safeguard the interest of their spouses. Especially female wives. Males are still independent. So then he's like, what do I do? So what we did is he released his 50% share in the name of his son. So the son and wife, his mother, became the co-owner of that house, so that his wife interest is safeguarded. At the same time, we said let the wife make a will, so that if something goes wrong, he to her, it will go to his elder son because of so and so reason, because he has already given the share of younger brother in liquid, to his younger brother. And then we made the younger brother the witness of that will, because the possibility to challenge that will, the person who can challenge that will can only be his younger brother. Nobody else is going to challenge that mother's will. So we made him as a witness, so that things are clear in black and white. So that the point was both the interests were safeguarded. The family could live in peace. They came to know the intentions of the younger son. The mother was secured for the rest of the life. At the same time, the elder brother who had invested so much of money was also secured. It became a win-win proposition for all three of them, the entire family. So that is the way we have to deal with every case.
Great. So, by the two examples, what I can make is a gift deed is probably a better instrument as compared to any other source of doing this. Thank you.
Yes.
And can you also, assets generally are categorized into movable and immovable, on a broader scale. So, where do you feel that the challenge is more critical? Is it in the immovable space or is it in the movable space?
Definitely in the immovable space, because there are a lot of taxation laws involved to it, there are inheritance laws involved to it, the registration part is mandatory. So I generally, if this is my personal perception, I generally, to my senior citizen clients and all, I would not recommend them to buy property. I generally do not encourage them to buy their property in their name. I generally tell them, you invest that money in movables, invest in something which is very easy for you to liquidize. So even the laws are a little complex with when it comes to immovable assets. So we definitely recommend this.
Great. Thank you. Kenny, we have a question from Karan. He majorly invests in real estate and has been recently introduced to financial assets as well. The question is, if gift deed is in case of gift deeds execution, does one have to pay stamp duty on property registration?
That's a very nice question. Thank you for the question. So now for gift deed, there are first thing we have to understand what is the property which is being gifted. That is it an residential property or it's a commercial property? If it's a residential property, and if there are propositions of relation which are mentioned in the law. So if it is going from a senior relation to a junior, say from father to son or father to grandson, or grandfather to grandson, or all of those propositions, then the stamp duty and registration charges in Bombay applicable are 200 and 200 each. That means 400 rupees. That's it. This is the minimal that you have to pay, and you can execute a gift deed and get the property inherited in the name of the person you wish to. But if it is a commercial property, then this is not the case. Then in that case, the stamp duty and the registration charges applicable will be variant, and it will be the 2% of 3% of the value of the share that you are giving. So here I would like to make it more simple. Supposingly father and son both are having a particular residential property or a commercial property, then in that case the if the property is being inherited, like waive off करना है, तो वो जो 50% father का share है उसके ऊपर stamp duty या registration charges applicable होगा, not on the whole of chunk of 100%. So that is how it is.
Great. So how I understand is, if it's residential, there is a fixed charge in Bombay, and probably the same would be applicable across. So the charges
Every state.
different. And if it's commercial, then it's just treated like a normal transaction, and we have to go through a registration process.
Yes,
Great.
yes.
And
And that is,
yeah, please go ahead.
yeah, so that is what we recommend, that making a gift deed is a very simple process. If you are very clear that there is not going to be the residential property ke liye, to this is the best way to do it, and it makes the person owner of that particular property immediately.
Great. Also, a follow-up question is, while execution of a will after death, does the beneficiary have to pay stamp duty as well?
Yes. So basically, will ke liye, when you obtain the certificates, probate certificates or succession certificate, so for Bombay the maximum court fee is 75,000 rupees. So any asset which is valuing more than 3 lakhs rupees, so then in that case 11 lakhs rupees, so fir 75 ho hi jata, and this is the minimum that anyone will have an asset. Apna Bombay mein, if you go for a basic house, it's going to be costing more than 1 crore, So 75,000 is the court fee, which can be kabhi bhi wo बढ़ सकता है, कुछ भी हो सकता है. So this is the minimum plus legal expenses. After you obtain that particular certificate, you have to go to the registrar's office, execute a formal deed of transfer, pay the requisite stamp duty, and do it. So that is why I always say that try to try, as you grow older, try to liquidize all of that, so that you save out all of that. एक हाथ दो property रख लो, ठीक है, for your safeguard. I understand if parents do have those apprehensions, if I bequeath everything and if something goes wrong, where do I go? I'll be homeless, or I'll be, so do it in a very systematic manner. Do not overhold things. At the same time, do not let go with everything. Balance it out.
Great.
And that's why I always encourage liquid assets are best, because it keeps you very much safe and secure.
Great. And Kenny, out of your experience, because this is your area of specialization, a lot of people who I have generally interacted to during their process of will creation, or, the next generation who is witnessing will creation, or is probably battling will, after death in an improper will or something like that. How do you, I know it's case to case basis, but how do you suggest to go around it in case of dispute? So if there is a dispute, generally I hope settlements don't go around, because a lot of emotion is involved when family is involved. So how exactly do we focus on resolving that dispute, and it not spiraling into years of years of asset not being accessible to any of the parties?
I would say it is someone's maturity to deal with the problem. I'll tell you one thing. This is the first case of my career, and that is something I always feel, what is the point? There was a father was wanting to separate both the sons and make them independently. It was a property here in Mumbai. Both the sons, the dispute started with 7 lakhs, or this is something in 1990. They started the dispute in 1995 or 1996. The dispute started for 7 lakhs rupees. The elder son was like, no, I deserve this, and the younger son was like, no, you do not deserve this. So the dispute started for some 7 to 10 lakh minimal amount, and then the dispute went on, the battle went on, ego, till date they are still fighting for the property. They must have spent more than 5 crores to 6 crores on advocates and the legal expenses and other. More than that, they ruined their personal relationship. They ruined their proposition, or abhi unke grandchildren are also not in talking terms. They do not know each other. Basically, they have never seen who is my uncle's son, who is my aunt's son. They do not know that it proposes. So I always feel it is always, the person who is the creator of the property has the command of that property, and if he acts maturely, if he does his succession planning in a very matured manner, then the proposition or the possibility of rifts are ruled out. Because देखो बिल बन गया, आप चले गए, फिर तो जो होना है वो होना ही है, वो आपके बात की बात है, बट आपके प्रेजेंस में. सो दैट इज व्हाई आई ऑलवेज से, इवन द लॉ ऑफ नेचर इज, the creator has to plan for its, everything which is created is going to get destructed someday or the other. But it is what important role is what you play, a constructive, what constructive role you play. If you act maturely, if you do it very clearly in your lifetime, in your presence, making it loud and clear, then the possibility of fights is minimal. You can actually make it to zero level.
Great. And Kenny, when the asset is in dispute, what happens to the asset?
So it becomes in such a situation कि वो किस टाइप का ऑर्डर लिया है कोर्ट से. So supposingly if one is in occupation, तो उसके पास occupation में ही रहेगा. So basically वो none of the legal heirs can enjoy it. They cannot sell it. They cannot enjoy the fruits of it. So it's basically stuck. It is the fruits of that particular property are not yielded by anyone. It is more of a rift. So like if son is staying in that particular property, तो वो रहता रहेगा और दूसरा court में litigate करेगा. So he cannot sell, he cannot have a future opportunities to walk out of that property or grow that property. Nothing. They are on stagnancy basis, status quo.
Great. And I think one question from Virender sir, he's asking of what are the advocate's expenses for a gift deed, a ballpark figure. So like a rough idea of
So
how.
the normal figure, no, I can definitely say that's nothing to, shy from. The normal advocate fees for making a basic gift deed is normally from 10 to 15,000. That's the basic fees normally advocates charge. You may find someone who may take 3,000 or 5,000. It's a subjective thing, but on in general, this is the minimum amount and the maximum amount in and around if it's a simple gift transfer of gift.
Thank you. So those were my questions. I would request, and of course, some questions from Karan and Virender sir. Any other questions from the forum? Okay. Great. So I don't see any questions yet in the chat box. Guys, we can also unmute ourselves and ask if we have any questions. If not, Kelly, before I let you go, and it was an amazing presentation, any interesting or because I'm sure, it becomes very spicy in the area of operations that you are in, probably in law. So any interesting incident or any interesting episode or anything that you feel that would also be a truth of fact for us and a learning for us who are not from the legal background or who have not seen things like that. Anything that you would like to share that you have personally enjoyed and relished being a part of?
Enjoyed se zyada learned, I would rather say enjoyed. So like, see, I was a practicing, I'll tell about my life thing, I was a practicing advocate. And for me, normally suits aate the, litigation aata tha and all of that. I had a very good friend of mine. Her father all of a sudden passed away at the age of 56. It was, and leaving behind his mother, who is 83-year-old, a wife and a daughter. The daughter was 21-year-old. Now, he never did any kind of succession planning in his life. They had multiple assets. Okay, so he, in fact, there were assets which were in his father's name, grandfather ke name pe, mere friend ke grandfather ke name pe bhi properties the. And he never bothered. Arey apna hi hai na, kya farak padta hai? He kept doing. There was no proper documentation for all his assets, movable bhi, immovable bhi. There are huge amount of assets. And one fine day he passes away. You can imagine the state of family. There are three ladies. There are three ladies, out of them two are homemaker, and there's one girl who is just 22-year-old, and she has to manage and run the show for the rest of her life. How difficult it was. They even didn't knew, where and what her father has, thankfully, with the grace of God, they had a person in the office who was with them for last 20 good years. He knew everything. So he was the one who came candidly to her and said that, "Hey, this is what your father has. This is in the name of your grandfather. This is in the name of your grandmother. This is in the name of your sister aunts, which is invested by your father. फादर ने टैक्स बचाने के लिए आपकी बुआ का नाम डाल दिया है, बट दिस इज ऑल बिलोंगिंग टू योर फादर एंड अभी आपको जो करना है वो करो. This girl was my best friend, you know, and she literally poured 3.5 to 4 good years. She was doing her engineering. She called off her plan to do masters in engineering because if she goes to US, we'll look after this ladies. 3 to 4 good years, she just invested in getting all the properties back in the name of her mother or herself, because the problem was aunts were good but few uncles were not good, you know. So she's like कि अगर दादी का property है, so if something goes wrong to my grandmother, again we'll have to go to them for seeking their NOC. एक property, फिर they had lot of physical shares, they had never converted them, you know, debate नहीं करवाया था and all that. तो वो physical shares को एक 19 से 60s के, you know, ढूंढ के उसका करके succession certificate, we had made a schedule of 500 pages. Can you imagine, in a succession certificate application? And we did it. So just imagine if that particular person would have been wise enough in his lifetime, he would have done gift deed किया होता या succession planning किया होता या will किया होता, कुछ तो भी किया होता, तो उनकी बेटी के 4 से 5 साल, or probably he would have not gone in this ways, you know, in assembling things and kind of stress that the entire family went through. So this is what it was my learning, that and hence that was an opening for me that no, I'll do the succession awareness program so that people understand that it is not easy. what हम सोचते हैं और जो law होता है उसमें बहुत फर्क होता है. it करना नहीं करना, that's a secondary thing, but at least understand, because this is the most certain event of your life, so at least understand it.
Great. Thank you. Thank you so much, Kenny. And like we always say at Together Investing Club, that unless you've seen it, you don't know what it is. So hence we invite people
I
like
totally agree.
you who have actually witnessed things like this to empower us and, you know, give us an insight. Thank you so much. It was a wonderful conversation, I guess. And any closing remarks from any one of us, Atul sir, Virender sir, anything from your end? I think it was a fabulous presentation by Kenny. So over to you.
I think it was very interesting, honestly. Um, so somehow uh, the tone is that people who have made a lot of money in life, they make a mistake of not doing things properly, and people who are going to receive all that wealth, they suffer because of this. That sounds like an irony, actually. They're getting it, and if they have to work for it, so be it. And they should not crave about it. That, you know, the person who's left this world, they have created a mess for our life. But yes,
Yes.
point taken, everybody should do their will properly so that the
Yes.
suffering as
They basically, yes, I definitely say that. See, finally, we are putting all these efforts for our loved ones, dear ones. And if they cannot yield the fruits of our hard work, then what's the point? And if we cannot trust them, then what's the point? And if we cannot make their life simple, then what's the point? And it is all about bridging this gap. The person who's going to inherit should have an utmost clarity कि उसको क्या करना है, and जो दे रहा है उसको भी clarity होना चाहिए. Then it is a wonderful way of, you keep investing, you keep growing, but at the same time keep your self very secure.
Great. Thank you so much, Kenny, for your time and for all the.
Thank you, it was pleasure being here.
Thank you. Thank you, Isha, for attending.
Thanks, Isha. Thank Kenny.
Thank you, Kenny, for your time and all the efforts that you've put in and the patience that you've had with all of us. I know it was a long due collaboration, but I am so happy that it happened and happened so well.
Thank you, guys.
Thank you guys, thank you so much.
Yeah.
Have a good day. Thank you, Deepak sir, also.
Wishing you all a very
Thanks, Isha.
wonderful weekend, whatever half weekend which is pending.
Yeah, I think many people will be working hard now.